Welcome to the Pro Bono Project YouTube presentation on expungement and using discretionary expungement forms in California. As a preface to this video presentation, this presentation addresses discretionary record clearance in both Santa Clara County specifically and California more generally. Mandatory record clearance is expungement for those crimes which the court clears as a matter of right once certain requirements are met. For more information on mandatory record clearance, please see our Pro Bono Project YouTube video presentations on expungement, record clearance basics, and on how to fill out the mandatory record clearance forms. Please be aware that this video presentation will only address discretionary record clearance using Santa Clara County Court Forms CR 180 and CR 181. There is a process you can follow for discretionary record clearance which does not use these forms, instead by filing a brief with points and authorities. This presentation will not address the latter process. Instead, this video will concentrate on those convictions which are not eligible for mandatory record clearance, and instead fall into the category of discretionary record clearance. So in discretionary record clearance is the judge's discretion on whether or not to clear a conviction from your record. Discretionary record clearance generally applies in situations where you received probation and did not complete all conditions of probation, or you did not get an early release from probation, or you were convicted of a violation that specifies that record clearance will always be discretionary. For example, a DUI, driving with a suspended license. You did not receive probation and did not complete all the requirements of your sentence, and 1 year has passed since your conviction. And in all of these circumstances, you must not be currently charged with, under supervision for, or serving another sentence for any other offense. Discretionary record clearance petitions require a court hearing. This is your opportunity to explain to the judge why the judge should grant record clearance in the interest of justice in your case, why the judge should use their discretion, and why you are deserving of record clearance. So what do you need to start a discretionary record clearance petition? To complete the discretionary record clearance, you need forms CR 180 and CR 181. You can obtain these from the Judicial Council Court website, from the Santa Clara County Court website, or at the Hall of Justice in Santa Clara County. To use these forms, you need to know the date or dates of your convictions, the code sections you were convicted of violating, and the code you were convicted of violating, such as Penal Code Section 211, whatever code section you were convicted of violating, you need to have that, the name and the number. You can obtain this information from your record arrests and prosecutions, or what's also known as your rap sheet. For help in getting your rap sheet, watch our short video on how to get your rap sheet on this YouTube channel. So forms CR 180 and CR 181, that's the petition and order for dismissal. After you obtain your rap sheet, to begin this process, you need to get those court forms. You will need a separate set of forms for each court case, but you can file one form for multiple convictions seeking clearance within a particular case number. For example, you were convicted of 2 separate penal code violations in Santa Clara County, case number C1111111. When you petition for discretionary record clearance for these 2 convictions, because they were both in the same case number, C1111111, you only need one petition. On the other hand, if you have 2 convictions in 2 separate cases, such as case number C1111111 and C2222222, you will need to file 2 separate petitions for discretionary record clearance. Petitions for discretionary record clearance have to be filed in the county where your conviction occurred. If you move while you were on probation and your probation was also transferred, you will likely file in the county where you finished your probation. Please check with your local authorities, such as the adult probation department or the public defender's office. You can obtain these forms that you need from the court clerk at the Hall of Justice in San Jose or from the California Courts website. There are currently no filing fees in Santa Clara County for record clearance petitions, but if you're filing in another county, check with your local probation department about possible filing fees there. And then finally, when filling out these forms, be aware that you are both the petitioner or the defendant. So anywhere it asks for petitioner or defendant, that is referring to you. So the first form, CR 180, the petition for dismissal, you can see a sample of that here on the right-hand side. When you're looking at this, you want to fill in the top left corner, fill in your name, address, telephone number, and email address. Where it asks attorney for, you write in self-represented. Then it requests the address of the court where you are filing. So here in Santa Clara County, it'd be County of Santa Clara, and then the street address and the county and zip code. The next section where it says people of the state of California versus, write in your name as is shown on your case record. On the right side, next to defendant there, it asks for case number, and then write in the case number you are seeking to have cleared. Leave blank the box below where it asks for date, time, and department. So when you're looking at your first conviction that you want to have cleared, on box number 1, write in the date of the conviction, not the date of the arrest, the date of the conviction. And then below that, you'll see that those boxes below, write in the name of the code you were convicted of violating, such as penal code, vehicle code, health and safety code, whatever the code is. And then next to that, write in the section of the code you were convicted of violating, such as 211, 212, whatever that is. Next to that, write in whether the conviction was a felony or a misdemeanor or infraction. Again, all this information is on your rap sheet. If your conviction was a felony wobbler and is eligible for reduction to a misdemeanor, write in yes. A wobbler is one that can be charged as either a felony or a misdemeanor. You can find out if your felony is a wobbler by looking at the code section. And if you could have been sentenced to either county jail or time in state prison, it is a wobbler. However, you must have served your time in county jail. So it has to be chargeable as either a felony or a misdemeanor, and you could have served in either county jail or state prison, but you did serve in county jail, in which case you can write in yes. The last box asks if your conviction was a misdemeanor and if it is similarly eligible to be reduced to an infraction under Penal Code Section 17D. The list of offenses eligible for reduction from misdemeanor to infraction is found in Penal Code Section 19.8A. So you can check the code you want to see if you can reduce it under that code section. And then you would write in yes or no. So if you were convicted of a felony or misdemeanor and granted probation, you want to check box 2 here. If you fulfilled all the conditions of probation, you will check box 2A. If you were released early from probation, so probation was not revoked, but you were doing great on probation and they said, hey, you're doing so great, we're going to release you early from probation, then you would check box 2B. If you did not fulfill the conditions of probation for any reason, such as probation was revoked, if it was modified, if you violated probation, check box 2C. This does not mean your petition will not be granted. It just means you now must explain to the court why, in the interest of justice, your petition should be granted. And this is what we're talking about here today. This is discretionary record clearance. So you can write on the bottom of page 1 or attach information explaining why the court should grant the petition in the interest of justice. There are three categories of information to include in process, if possible. Your explanation why the court should grant your petition, letters of support, and certificates or documents of programs that you completed. Please recall that record clearance petitions are signed under penalty of perjury and that everything in them is true and correct. You can consider having an attorney review your documents on your behalf to ensure accuracy. So a special note about fines and fees. If you owe fines and fees on the cases which you want to have cleared, that does not mean the court will not grant your petition for record clearance. But first, you want to contact your county Department of Revenue and find out whether all your fines and fees for each court case were paid. If so, include in your petition a statement that all fines and fees were paid, or if that they were not, and then the amount that you still owe. You can still seek record clearance, again, even if fines and fees weren't paid. Inform the court and request a waiver of the remaining fines and fees, or ask them to be converted into a civil judgment so that record clearance can proceed. Victim restitution is treated differently. The court will not waive victim restitution, but you can ask that it be converted into a civil judgment. So your statement to the court for discretionary record clearance as to why it should be granted in the interest of justice. This is going to be different in every case and for every individual. So information you want to think about including steps you've taken since your conviction to improve your life, such as you are attending Alcohol Anonymous, you no longer drink, Narcotics Anonymous, you've been to rehab and you're sober. Whatever steps you've taken since your conviction to improve your life and get it on a better track. Why you deserve expungement and how it will help you succeed. Again, so you were going through a rough patch, but you've improved your life since then. And record clearance will help you get jobs, housing, and it will just help you prove to yourself and your loved ones that you're doing better now. Some examples of this as to why you deserve expungement and how it will help you succeed, steps you've taken to improve your life: community service engagement, volunteering, church attendance, that you've graduated from school or you're attempting to continue your education, that you've found stable employment or you're trying to find stable employment and your convictions are holding you up. Your family life, what's going on with your family, and if you have children and how you're able to be part of their lives. Anything to support why granting record clearance is in the interests of justice. Explain to the court where you were in your life that led to your court issues. You want to give them the context to consider where you were so that the court can fully appreciate the steps you've taken and where you are now. You can also include signed letters from community members supporting your application. This provides proof for the court that the positive outcome that record clearance will have for you. You can obtain letters from people you've worked for or volunteered with, or coworkers, family, friends, people who know you well and can describe the efforts that you have made to improve your life. Again, these are people that can talk about people who knew you in the past, kind of where you were and the progress they've seen to where you are now. You can also include certificates from programs you completed, such as treatment programs, parenting classes, trainings, diplomas, certificates. You want to include anything that explains to the court why it should grant you record clearance. If you need additional space to explain why the court should grant your petition in the interest of justice, you can attach Form MC-031. So on page 2 of Form CR 180, again, at the top, write in your name and case number as on the first page. So checkbox 3, if you were convicted of a misdemeanor or infraction and not given probation. Below that, checkbox 3A, if more than 1 year has passed since the date of your judgment, and again, you've had no negative contacts with law enforcement, you are not serving another sentence, you are not under supervision, you are not under any charges, and you comply with the terms of the sentence. If you do not meet the requirements of box 3A, check box 3B. This informs the court that you are seeking discretionary record clearance. And this is what we were talking about on the previous page. And that's where you'll again include those explanatory materials. So if box 3 doesn't apply, take a look at box 4. So check box 4 if you were convicted of a misdemeanor with probation under Penal Code Section 647B, and you were a victim of human trafficking. If you are a survivor of human trafficking, you should speak with an attorney, as there may be other relief available to you. In clear and convincing evidence, you need to prove to the court that you were a victim of human trafficking and you were convicted of violating Penal Code Section 647B, and the conviction occurred while you were a victim of human trafficking, and you were given a term of probation. Your attached information and declaration, if you are a victim of human trafficking, should have described all the available evidence that you were a victim of human trafficking and explain how the conviction was the direct result of being a victim of human trafficking. Include any documents, letters, reports, or other evidence which supports your claims. Down below, box 5. So box 5 applies to prison sentences which were served in county jail after 2011 or felony state prison sentences. So county jail prison, check box 5 if you served in that category. Check box 5A if more than 1 year has elapsed since you completed your county jail prison sentence with mandatory supervision. Check box 5B if more than 2 years elapsed since you completed your sentence without supervision. And in this case, as all others, you must not be currently under supervision for any crime, not serving a sentence for any crime, are not on probation for any other crime, and are not currently charged with the commission of any offense. So box 5C refers to felony state prison sentences. So again, you would check box 5 if you received a felony state prison sentence, and check box 5C if more than 2 years have elapsed since you completed your felony state prison sentence and you are not currently under supervision for, serving a sentence for, or on probation for any crime. And you must not currently charge with the commission of any other offense. Here is this is discretionary record clearance for all of box 5. And you want to explain to the court why, in the interest of justice, the court should grant your petition for record clearance. This follows the same pattern of a declaration, letters of support, and attached documentation as described above. So on page 3, again, at the top, write in your name and case number as shown on your case record report. Box 6 applies to pre-2011 prison sentences that would have been eligible for a county jail sentence under Penal Code Section 1170H5 if they had been prosecuted after 2011. This would be indicated on your rap sheet. To be eligible for relief under Penal Code Section 1203.42, you must have been sentenced to state prison prior to January 1st, 2011 for an offense that would now qualify for sentencing under Penal Code Section 1170H. You must not be currently facing any new charges or serving any other sentence. The offense must have been non-serious, non-violent, and non-sexual. Please see our other YouTube video record clearance presentations for more information on what qualifies here. If you meet these criteria, you are eligible for discretionary record clearance 2 years after completing your prison sentence. Again, you want to explain to the court why, in the interest of justice, the court should grant your petition for record clearance. This follows the same pattern of declaration to the court, letters of support, and attached documentation that we previously survived. The last section here on page 3 is box 7 for a deferred entry of judgment. If you received a deferred entry of judgment for your offense, check box 7. If you are eligible for deferred entry of judgment, you should consider talking with an attorney, as you may not need record clearance in some circumstances. In the first paragraph, you want to write in the date the charges were dismissed. Check box A or B, depending on your circumstances. And if you check box B, you should indicate whether or not you are attaching your rap sheet. The last thing to do here is date and sign your petition. Also make sure to print your name on the line where it asks you to do so. The second form you need to fill out for discretionary record clearance is Form CR 181, which is an order for dismissal. Most of this form is filled out by the court, but you do still need to fill out the top half. So you'll complete on the information on the top, on the left, this exactly as you did it on Form CR 180. This includes your name, address, email, telephone number. You would also, where it asks for attorney, you write in self-represented. The information below that is the county where your petition is being heard, such as Santa Clara County. And then below that, people of the state of California versus defendant, write in your name as it appears on the case record. And then on the next line to the left, you want to write in the case record number, which you are seeking clearance. On page 2 of this form, write in your name as it appears on your case record, and case number is on the first page. And the rest is left for the court to fill out. So after you've completed your forms for discretionary record clearance, they must be filed with the court and served on the adult probation office and the district attorney in your county. To file the petition with the court, you want to make 3 copies, and then you take those copies and your original signed documents to the clerk's office at 150 West Heading Street in San Jose. The clerk will file stamp the copies, return a copy to you, and assign you a hearing date. After this, you must fill out a proof of service and file it with the court. So service means copies of the forms are given to the district attorney and the probation department of the county where you are seeking record clearance. You can get this form CR 106 from the clerk's office or the California court website. These forms must be served by someone else, not you, but you can help them fill in the information. So they will fill in the information for the person serving the papers as follows. So on box 2 or circle 2, they will write in their name and address, write in the list of the documents being served. That would be Form CR 180, petition for dismissal, and CR 181, order for dismissal. On the top right, write in the name and the address of the county court where you are seeking record clearance, such as Superior Court of California, county of, and then you would write in Santa Clara and the address of the court. Below that, write in the case number, and then below that is the case name, which is your name as on the record that you're seeking clearance. If the individual is serving by mail, they'll go to number 4. These forms can be served, Form CR 180 and CR 181 can be served either personally or by mail. And again, this must be done by someone, not you, who is over 18. If they are serving by mail, number 4, on number 4B1, who the documents were served on. So if your case was prosecuted by the district attorney, write in the name of the district attorney in the county where you were tried. If it is prosecuted by the city attorney, write in the name of the city attorney in the county where you were, or the city where you were tried, or the county. The adult probation department for the county where you were prosecuted is number 4B2. And then write in the date the documents were mailed and with the city and state where they were being mailed from. And then that individual will check the box on how they mailed them with the U.S. Postal Service or at an office where they were picked up from the mail. On page 2, this refers to where someone is personally serving. At the top, write in the case number at the top of the page. If they're serving in person, they would fill in number 5. And then they must sign and date the proof of service at the bottom. For serving number 5, you'll write in 5A, write in the name of the agency served, such as the Santa Clara County District Attorney. 5A1, their address. 5A2 is the date when they were served in person, and 5A3 is the time that they were served in person. Number 5B is the Adult Probation Department. So they would write in the name of the Adult Probation Department. 5B1 is the address of the Adult Probation Department in the county where they were serving. And again, the 5B2, the date when the form was given to the Adult Probation Department, and 5B3, the time where they were given to the Adult Probation Department. And again, the person serving must sign and date the proof of service, as well as handwrite in their name next to their signature on the line provided. The signed original copies of the proof of service must be filed back with the court clerk's office after service is completed. Some final notes about discretionary record clearance. You should receive a file stamped copy from the court clerk with the date and time of your hearing for discretionary record clearance. This is your opportunity to talk to the judge directly and explain why granting you record clearance is in the interests of justice. Thank you for listening to the Pro Bono Project YouTube video presentation. On record clearance.